Okay, we're back live here just a little bit after 10 o'clock. General housing, and I just wanted to open the floor up to a conversation on what we heard yesterday from Damien on H66. Walkthroughs are informational and sometimes tedious, and sometimes it's a lot of information. We only got through from a content perspective, we got through 1/3 of the sections basically, or we didn't quite finish the section on the wage replacement program. And then we're going to hear from Damien today to hear about the FMLA changes just for the unpaid leave, which will be the foundation upon which the wage replacement section is laid. And the third section on safe leave. And so he'll walk through that in a little bit. He's in another committee right now. He's going to pop over here because he's in Commerce next door. Any questions, thoughts on what we've heard so far, whether it's about content or whether it's about just the process of doing a walkthrough like this and doing this thoroughly for those of you who are new? This is kind of what we do with walkthroughs. Not all bills are 43 pages long or 48 pages long, whatever we have here. So, questions? Comments? Yeah, Representative Parsons.
Thanks. My comment would be that I'm really curious to see if an insurance plan that matches this program would ever exist. One of the things that I think about is if your private insurance plan has to mirror this or be better, how would you get unless the employer just paid your section of it, if you have a part-time employee who makes under $25,000 a year in your company, in order to match this, they wouldn't have to pay for the program. You couldn't make them pay. So if you had your private plan, you can ask that employee to pay into it.
Can you explain that last?
So let me see if I heard it. So is this I'm an employee, you're my employer.
Right.
Employer doesn't want to pay into it and says but the employee does?
No. I'm saying I'm the employer.
Yeah.
I say I'm going to go with a private plan. I look for a private plan. I find a private plan. You work for me. You make under $25,000 a year. Then this you don't have to pay.
Right.
According to me as an employer, I say I pay half, you pay half, but you don't have to pay half now. So as an employer, how would that work? All right, so it wouldn't be it wouldn't match this plan. You wouldn't be able to ask an employee to pay in.
If they were under 25,000.
Correct.
No, that's a question out on the table.
Yeah. So my big concern is that as it sits, unless told otherwise, I'm having a hard time believing that an insurance policy exists.
But in a private area.
For a private company to purchase.
Right.
For a company to purchase a private plan,
right.
I should say.
So the administration is working on negotiating right now about state employees, and they're negotiating with a private insurance company like this. Obviously, this isn't in place, so at this point in time they can do that. But I guess the question is there actually an insurance plan out there? Could we get a quote from a private insurance company
Like if you were to bring this to an insurance company and say, what's the private plan that I can purchase that matches this?
Yeah, and how much would it cost?
And how much would it cost? I think you'd either get two options. Doesn't exist, or it's gonna be way more expensive.
Okay.
So I'm, in my thought, I think we're kind of putting out you have an option to go this route, but you really don't.
Yeah, okay. Representative Eldridge, James?
I'm interested, it's an interesting question, and I think to clarify, Representative Parsons is kind of asking like, would the exemption for $25,000 itself be deemed by DFR as one of the check marks you have to hit to be equivalent? And so therefore, barring having a $25,000 exemption, no private insurance could be deemed by DFR to be equivalent. Is that, yeah, and that's interesting. The other thing I'm kind of interested in is that section that we covered last about that same exemption of $25,000. The way it's written, I think you have to pay it either way. So you got this 0.58% and you got 0.29 being paid theoretically by the employer, 0.29 being paid by the employee. The way this is written, at the end of the year, if that person's found to be exempt, they're actually going to get back their 0.29 as well as their employer's 0.29. So they're going to get back the whole 0.58 the way it's written now, which is kind of interesting. So they'll actually get some money back that they didn't put in.
Yeah, well, right, so there's your complication. So if your employer, I mean, at this point, the bill is calling for a 50-50 split or better.
Right.
And so how do you know, which one is it gonna be put on your pay advice
Right.
that is the pay advice gonna show the 2.9 or 5.8?
Right. And if your employer puts in the whole 0.58, they'll pay it all year and you'll get it all back.
Well, it won't show up on your pay advice.
It won't show up on your pay advice. That's true. But this
It does.
says that all contributions must come back as an income. And that's part of the contribution. So as defined here, the commissioner would have to send them that 0.58 back.
So circle that as a question for the tax.
Yeah, you could say like all contributions made by the employee.
Representative James?
So I'll just do my final caveat. So I missed our testimony on Tuesday because I was home helping a child recover from surgery, which was interesting as a family medical and leave, as we were walking through a bill that would have applied to. But so I haven't quite caught up on listening to all of our testimony yet. So if we've already discussed this, just cut me off. I am curious about what I heard in part of our testimony, which was that one option is that the rate would be set every year by the legislature. And I'm curious to find out how that would work, how we keep politics from bogging that conversation down every year, and whether the fund is self-balancing like the ed fund, so that we're required to set a rate that will fully meet the needs and we don't wind up with unfunded liability.
Right, so the goal is.
We talked about that, sorry.
No, but so my understanding is that it has to self-level. It's possible that if the fund raised not enough, they're gonna issue a report on the health of the fund, I think by February 1st every year.
It recommends a rate.
Which recommends a rate to, based on the previous year's usage. So if it was used quite a bit and they felt like their reserve level, I think they're choosing from JFO's testimony yesterday, they're talking about having a 9-month window. And so if they get their fund down to 8 months in their projections based on the usage of the year before, that they would recommend a higher payroll tax. And I believe the goal, if in fact it was not used much, it would bring the rate down. But that would change based on their report. And I get with your politics because of,
It's the word recommend that makes me nervous, because I feel like I'm likening it a little bit to the yield, I guess, where maybe I just can't draw the parallel.
You have to think about it in terms of workers' comp.
Okay,
So workers' comp is insurance. And because of the usage of it and by the injuries in the workplace, the rates dropped for 7 years in a row.
Yeah.
And that's after they've done the work, after the state has done the work. And they're saying we don't need to take 1.45%. The fund will, will be fine at 1.38. So it'll be a drop in the tax, and that's the tax to the employers. So that's more closely related as an insurance plan, whereas the education fund is all about expenditures.
Ed fund mode, okay.
Representative LaBounty?
Yesterday, if I remember right, JFO said it's gonna be like $80 million to implement this plan, going forward.
No, they mentioned that it took Washington State.
Oh, Washington State, 80 million, that's right.
But there's two $80 million numbers. There's the Washington State, that it cost Washington State $80 million over X number of years to implement their programs for whatever reasons. For this fund, not the implementation. The implementation is unknown. We've heard numbers ranging from $2 million to $20 million over the years about how much it would take to just implement the program. But in terms of fund health, $80 million roughly $80 million would represent what it would take to keep the fund solvent. Or that may be the target number to keep the fund out that levels out over time.
Yeah. Well, I was just curious on if we went through an independent insurer, that would be their issue to, develop the software for this and everything else. So that would alleviate, some money away from, the employees or employers at that time. But, also, I was kind of thinking about the idea of it would be up to the insurer to make sure that fund is solvent, not so much the state itself. And, would that alleviate some of the pressure off from the state worrying if we're going to be able to pay this out or not? But we need to know how much the private insurer is going to charge too to implement all this.
Yeah, an insurance company obviously is going to have money that they would. They're insurance companies. They collect money every day. So the difference between going with a private plan and going with a self-insured plan like this is that we have to build up that fund that they think is a safe level. Whereas an insurance company can just assign reserves for that purpose. So it makes it a start, but we still, they have the safe full of the money that they need in order to run a successful insurance company. 15 months preparation and collecting funds before benefits would be available here would be the state attempt to create the safety zone. Representative Parsons, and then over.
Yeah. Do you have anything?
Oh, yeah, sorry.
Go for it.
It's very quick. Maybe I missed this. What about non-union government employees? Are they covered?
Yeah.
Okay.
Representative Parsons Elder Labor.
I think my hand covered hers and I went like that. I think one thing to consider yesterday, we heard from JFO, was with this being the only plan that covers 100% up to that 13 or 1135 or whatever it was. It's really hard to say that it's not going to have the highest usage as well, because let's say it's not an incentive to pay, 70-60%, but it's a deterrent from using a system kind of a little frivolously at times to say that if you're only getting 60% of your pay, it's a little harder to say I'm just going to use it because it's convenient. I could make it work.
Yep.
So I think that's something that just stuck with me from yesterday. There is no other plan that offers 100% coverage to that, which is a pretty decent sum of money. So.
Yeah, and again, we will hear more testimony on how it's split out between, I think Damien started talking about it and JFO didn't really go into it about how the difference between how benefits are taxed. Certain workers' comp is, I believe, is untaxed, or just, I'm trying to think of one of the family leave bills. I think the family, whatever it is, I mean, I know we've had these conversations in the past. Again, it's been 4 years since we talked about this bill in detail, but certain benefits get taxed, certain benefits get untaxed. And Damien did start talking about, yes, the recipient of 100% of untaxed income is going to have a liability later on. And that's different than the generosity issue that you're talking about, but that money has to be, we have to, and I don't think we'll solve it in this committee, but in the Ways and Means Committee, when they break down how it should be, how these are taxed. We'll get towards that level, and then you can say, well, is it 80% of the income or 100% of the income? But I get what you're saying.
Yeah, if I just add on to that, the thing that the two parallels, I guess, would be that, we're saying Rhode Island's done this for a long time. They've got this, they've got this figured out, and they just barely bumped up to 60% from 40. I believe is the number. If they're saying we think we can make 60 work at this point in the game, to jump up and say, we can make 100 work, seems a little, maybe pushing the envelope there. So,
and I'm gonna let Representative Bartlett jump in.
Yeah, I'm good. I'm gonna.
Really quickly, I have the table that JFO was using. Would it be helpful if I sent it to Ron so everybody can see it? Or I could throw it up here?
Sure. Why don't you throw it up? Right in. You co-host.
Throw it up. I need a copy of it.
Yes. I will send that to you first.
Make Representative Bartlett a co-host. Representative Labor.
Thank you. We tried that at our hospital, but the population group was much smaller. It was only 600 something employees. And when we modeled it, we ended up where Rhode Island is now at 60%. When it comes to taxable and non-taxable, and Ashley can correct me here if I'm wrong, it was who paid the premium. If the employee paid the premium, then it wasn't taxable. If the employer paid the premium, it was taxable. How are you going to split that in terms of percentage? If somebody's paying 50% and 50%, then the administrator of the program has got to have the software to do that.
Yeah. Now that's that.
100% is pretty rich. I don't know what you're going to find a company.
Well, we don't receive 100% of our income. I mean,
Right.
we get $802 a week. No, we get a little bit less than that after tax. And I think that speaks to whether it's taxable income or not taxable income. 60%, 65%, 70% of taxable income is the equivalent of our paychecks. So. Chestnut Tenterman, and then back to Representative Bartlett.
So, I'm hearing a lot of the technical questions and nuts and bolts. I'm kind of defaulting to the philosophical underpinning and to piggyback on Representative Parsons' question about the 60% being something that can be an emergency bridge if needed, but wouldn't be frivolously used or something. And I'm thinking absolutely that's true. I get that. But also then if I'm paying into a system, do I want it to be something that I can actually benefit from? Or do I want it to be something that will be that hopefully I'll never benefit from because I won't be in that situation? And, that's less of a balance sheet question than a philosophical framework for, is this something that we want people to use, or do we want people not to use it? Do we want to minimize use of it or maximize use of it? And I'm leaving that as an open question.
And Representative Barley, did you have a comment specifically on the chart or just to say,
I just wanted everyone to be able to have access to this. It's pretty much a breakdown of what states offer what and when they started. So your first table, you have the states, and then if you can see, Rhode Island, Connecticut, Oregon, Colorado are the only other states that offer the domestic violence or safe leave that we've incorporated in this bill. But just to kind of piggyback off of Representative Parsons, you can see that Rhode Island just upped to the 60%. And then it also has the breakdown of the max weekly benefit and then the opt-in for self-employment and then job protection. I found this very helpful earlier in the week when we first walked through the bill. So I just want to make sure everyone had access to it.
Thank you.
yeah, that was a JFO document, right? JFO produced document?
Yes.
So now it's on our website.
Great.
Or it will be. Right, so you can see everybody's all over the map and there's, you know, you see things like 50% of average weekly wage and over a certain amount, you know, so deciphering that will be part of our homework as well. Representative Elder, or no, I'm sorry, Labonte?
Yeah, just to, piggyback off from Representative Trisha King said about, the individuals by capping it, like, say, like 60%, 60% is quite a deviation between what the individual is making, for the week. And we don't want to deter them if they have an illness or if they're injured or if they might have a child down in Boston. We don't want to deter them from not being able to say, yeah, I want to, use this plan. I'm paying into the plan, but, I'm not going to get enough back from this, or I'm going to, lose money or so forth, that I'm not going to use the plan. And so I think there's a fine line between, too generous and going too low. And so we need to make sure that, we've all seen it in the workplace where, individuals don't have any personal days or sick days and they come to work sick because they can't afford not to, and then they end up getting their coworkers sick. Well, who benefits from that? So I think this is something that we really got to be careful of, that we make sure that, whether it's going to be too generous or not generous enough. And unemployment is a perfect example. You only get 56% of whatever your wages were, and then you get taxed on top of that. And then if you had any benefits where you worked, you lose all that. So, and it's very, very difficult for individuals to find a job that might be compatible to what they were making before. And then also on the other hand, the jobs out there, they might be making more on unemployment than they are being able to find jobs that are, equal to what they had before. So, there's a whole mixed bag in there.
Dennis, from your experience with working with the union, does a union contract in general, I mean, I know every organization has to negotiate a different contract, but is this a policy that would be included these days in a union contract?
This one here?
Yeah. Family leave of any kind.
Well, no, other than the federal, of course, but no, there isn't, not to my knowledge. I've never negotiated any contracts that had a paid family or medical leave.
It just had CTO. Representative Crescent?
I could be wrong, but perhaps teachers though in the NEA might have.
Yeah, that's out of my realm.
Right, I know, I was just saying another union that I think has paid family and bereavement and other leaves.
Yeah, I'm not sure.
Thank
But the bill doesn't affect.
Right, no, I know, I
Anybody who
was
negotiated.
just saying.
I'm just, you know, it's,
Yeah, one thing about, in most union contracts, they do have, some have, generous amounts of, sick days, which you can accumulate. You might have one sick day a month, and you can accumulate them, and sometimes it can even go into the next year. So you can have that in reserve if you do get sick or you're injured or you need to take care of a family member. So that's one thing that, we do negotiate.
right, but the difference between those programs and this is that this is an insurance program.
Yes.
It's not, if the employer chooses to be more generous and pay for all of it, or they can choose to offer more weeks, they can choose to do, a number of things, but this doesn't roll over
Yeah, no, that's
in
correct.
a 12-month period. Like you can't end up with 36 weeks of paid family leave in one 12-month period over the course of years if you never use it. And it's not use it or lose it. It's an insurance program, so it's just there. Representative Bartley.
I have a few questions. Just to start, so currently with FMLA, I just had a baby in the last year. I had to go to my doctor and say, here is my paperwork. I would like to take the 12 weeks. Please write it for 12 weeks. So my concern is you have somebody with an illness or just went out on leave or is planning on taking leave for, a birth of a child. And who's going to dictate, are we going to have an automatic, you just had a baby, you get the 12 weeks? Or are we once again going to rely on practitioners saying, no, I think you only need 10 weeks? Is there going to be somewhere that we can look back and say, okay, like I said, you get the 12 weeks, or you just had surgery on your ankle and it's an automatic 5 weeks? How are we gonna do that?
I think there is a section that talks about how do you apply. And all I'm flashing on now is if you had if you knew that your due date was February 2nd, chances are you'd be applying for the leave well in advance.
Yes.
Which gave you time to then, but I believe you need to have a doctor's note in order to apply anyway.
You do.
And so it's a good question. I don't know what it's like to go through and say, if the doctor said, no, you only need 10 weeks.
Mm-hmm.
If you have 12 that you're available for, this is the difference between, I think this is, I'll just go back, I think specifically to your question. I think that there's a level of appeal that's in here. But again, having a state-run program means that the questions and answers stay right here in the state, as opposed to going to a private, wherever the private company is located. And then we did hear from the series of appeals that can go on. So it's still going to be the same process. But again, never having done it before, I don't know what, if you did all your homework and you applied, well in advance of the anticipated birth of your child, it shouldn't be a problem. But how that is executed would be up to how well the program is being run.
And my other question goes back to the idea of a private plan. If I was understanding Damien correctly, length of leave is not addressed in use of a private plan. So they could have, 100% follow everything that the state plan would be. They can say, we're only going to cover 2 weeks. Am I misunderstanding that?
If the private plan only covers 2 weeks, let's say that's a negotiated contract. Then the department, the director, whatever this group is, would have to make a determination whether or not that is sufficiently generous to match the program.
Okay, so it's, okay.
That's a decision for when they make that application. Representative Burrows, then Elder?
Thank you. My question has to do with the dearth of doctors in certain parts of our state. And whether the requirement that, let's say you get COVID or another pandemic and you start off not terribly sick, but you get sicker and sicker. And so you don't have something like cancer where you go through a whole process and come to a specialist. You're instead being diagnosed by a test and treated by PCP. And there, like in our area, we don't have very many MDs. We're largely treated by PCPs. And as you have COVID, as it gets worse, how are you going to maneuver that permission process?
Well, I think the draft says physician, right?
Yep.
There have been, and Damien mentioned this is in passing as a consideration for us to that point to say perhaps it's a medical professional of some kind, that has that ability to make that determination, a prescription. But which was pointed out that's the way it's written in the federal law. And so adopting it shouldn't be an issue. It is an issue for those practical purposes. It's an issue for some religions. And but having the phrase medical, whatever Damien was suggesting, is something to consider.
I just want to follow up on something you had said. Does DFR evaluate a business's program against the state's program, even if it is a negotiated agreement? I thought if it was a negotiated agreement, that analysis wasn't done. But that analysis was done if it's not a negotiated agreement. Does it make a difference whether an agreement is negotiated on whether or not DFR judges whether it's equivalent?
Good question. I can't answer. I mean, breaking an existing contract, there might be.
Right. I guess I thought that was an exemption in this bill, but maybe not, because otherwise.
Not clear on that. We can ask Damien, and then I'm stuck on, anybody coming forward and saying, I want to buy this plan from this insurance company. And that department would determine whether or not it was equivalent or not, but I don't know about previously negotiated.
Okay.
Is there anything else anybody heard in what was presented yesterday? And can you check on Damien just to see? I know he's working, but.
We have a running correspondence going. He's deep into the second bill, which is
Okay.
a bit short. He's hoping 10:45 to 11.
Okay. Yes, Representative Barton.
And speaking with JFO yesterday, they had mentioned that not currently in the bill is should we be setting a minimum number of hours taken or intermittent versus continuous leave? I think both of those would be important to address. Just because, if it's intermittent, hypothetically, someone could continuously be using this program.
Right, the example used is that if I know that I have 3 chemotherapy appointments, given the state of our world months in advance,
Yes.
that I can apply for those. And then there's the element of it that I need clarification on, which is talked a bit about in an emergency basis, where if a woman had a premature birth and hadn't finished the process of, or hadn't started the process of applying with a set date in mind. There's a past tense, there's a you can apply after the fact, get reimbursed moving forward, but that, and I think that emergency perspective works for if I get into a car accident. I need to take time out and apply at some point soon after, but yes, getting having intermittent or saying, can I do half-day increments? Can I do full-day increments? Do they have to, whatever the increments are, we could certainly adjust that. Did you have a question? Did you represent Jackson?
Continuing discussion, I think that question of the, full day, half day, what's the time frame? Because we're talking about a 5-day period to approve an application.
Within 5 days, yeah.
Within 5 days.
Well, within 5 days
Unless, and then within 15. And I guess, like, I'm wondering if I were sick for a day, couldn't go to work, would I bother doing an application to be approved at some later date for a day's?
But that's not what this policy is about. It's
That's
about
true,
serious, it's
doctors-
defined as serious
doctors,
illness.
Physicians.
You'll have sick days, and that's what you would take off if you were sick one day.
Right. Not everybody does have sick days, but
No,
Yes.
everybody has sick leave. I'm sorry, we do have sick days within reason. Yes, you have to qualify in a couple of different ways. You don't automatically have them in the business, but they should be available to most people.
I was just gonna say, you should have a minimum of 5 days, whether you have that available.
mostly been self-employed. I don't have them.
It's very different.
Representative Elvin?
Oh, just that I answered my own question about collective bargaining. Collective bargaining agreement shall not diminish the rights provided by this section. So no, they're not exempt. But Damien, you'll get to that.
Actually, this is more of a, I don't know if it's an unfair question, but just from your work. The pandemic, it's March 13th, 2020. The world changed in terms of leave and schools being closed or classrooms even being closed or bus routes being closed because of exposure. Federal government, if I'm not mistaken, covered in a different way than paid leave.
Yes.
Can you just fill us out on the historical stuff about, because there was a conversation about possibly starting a paid leave, national paid leave program. But I know that employers got what?
Yeah, so it kind of happened in steps where the first initial paid leave, I think it was through FFCRA, which is the Federal CARES Act, pretty much said, if your kid is out, if you're out, if you have the sniffles, you're covered, we're going, and it's been a few years now, but I think it was 60%, we're gonna cover you, 2/3 of what your, take home is. And then what happened was money started running out, so they allowed employers to do this optionally. And what would happen was if your employer said, yes, I want to continue to offer this type of coverage for my employees, they would get a credit, a payroll credit at the end of the quarter. And they did that until September 2021. A lot of employers said, we can't afford to, even with the credit, to do this, and so stopped as soon as the federal money ran out. But it was very all encompassing. So if your kid's school shut down, if your daycare provider pretty much said, if you have to provide for your child and you cannot come into work, or, you had, because at that time it was 10 days, you were covered. But it was strictly just the 2/3 of what your take home normally is.
So with the work at home mandates, we totally, again, changed the notion, or
Yes.
when I had COVID, I kept working online. But since late 2021, there's been I'm curious that some people are coming back to work. We've come back to work slowly. A lot of companies have started saying only 2 days, or whatever it is. I always feel like there's a notion of, I'm not sure where the balance is going when an employer can say, oh, your kid's home from sick, it's not a school day, it's a sick day, they have to be sick. But how that works with any kind of leave program is just an interest. I don't know, it's more philosophical maybe right now for me.
Yeah, it's been really interesting, because especially these types of leave programs, as you said, a lot of us may have been able to continue to work from home. And if you were able to continue to work from home, you didn't need these programs put in place. So it really benefited those who were in the positions where they had to physically, plant workers,
Teachers.
teachers. So it definitely did not benefit the whole. But, most people were able to continue to work from home.
Yeah, it's just, again, it really is, I mean, the difference between now and 4 or 5 years ago is that we have this practical example of what's happened. And it's not necessarily perfectly parallel, but I think we've all experienced at some level that notion of, I have to stay at home, whether it's not just people with children, it could be, your spouse, it could be your mother, it could be your parents or something like that. So, welcome, Damien.
Thank you.
Did you catch a breath in your walk over here?
I did not, but that's all right.
Sure.
It's good endurance training here. Keep that heart rate up.
All right, because if you need time, we can take 5 minutes now, or
That's fine.
jump right in.
Let's just keep going.
All right, but no, we're due for a break in about 15 minutes, so we can do that and then come back till lunchtime. So what page are we on, Damien?
33. So page 33 of 48.
And we've been having some conversations, and there'll be some questions and some classic kind of, questions, clarifications, what ifs that we've been covering, just in conversation this morning.
So, section 2 of the bill, I know, isn't that painful? We only did one section in 3 hours last time.
But what a section.
It was 33 pages of new language. So, section 2 amends the tax law. And this is information, or this is the provision which allows the Commissioner of Taxes to share tax return information. As you can see, by the way, we're adding subdivision 22 to this. There are 21 other instances in which the Commissioner may share tax return information for limited reasons. This would allow the Commissioner to share it with the Treasurer, the Commissioner of Financial Regulation, and the Director of the Division of Family and Medical Leave, provided the return or return information relates to the provision of family and medical leave insurance. So this is basically just allowing the tax department to communicate with the division for purposes of administering the program.
Excuse me, hold on a second.
This happened in another committee. We have a little issue with closed captioning going on.
The issue with closed captioning, and I don't know how much we've talked about it, is that it's public, so, and it's not very accurate. So the issue is that it's being seen on YouTube, right? And I think, do you want to
Well,
text the participants?
The message right there says participant turned it on, so if whoever turned it on can turn it off, I can't, I don't have control of it.
That wasn't you, Dan.
Do we have a choice of just living with it for this morning, or just?
Yeah, I'll
Still on
send,
issue?
yeah, I'll let IT know.
Okay,
It says view controller for more information.
and it looks like it just went off.
Uh-oh, is that me?
No, I think it was on.
No, it was on earlier.
Okay,
Okay,
okay. All right,
so wait a
so
minute,
section 3,
wait, what page are we on?
page 34, just like that. So, yeah, so section 2 allows information sharing on tax information. It's language we have to have in here if we want the Department of Taxes to collect the contributions and to share the necessary information with the division. Section 3 sets deadlines for the adoption of rules. On or before April 1, 2025, the Director of the Division of Family and Medical Leave is required to adopt rules to implement the program. Commissioner of Taxes by the same date, in consultation with Director of the Division of Family and Medical Leave, is required to adopt rules necessary to carry out the provisions of the section governing how contributions are collected and the section governing refunds. And then Commissioner of Financial Regulation by the same date is required to adopt rules in consultation again with the director of the program necessary to carry out the provisions related to providing a private plan in lieu of enrolling in the state program. And then on or before October 1, 2026, and this gets to a definition that we didn't discuss in the walkthrough. So the definition of family member includes a provision that relates to individuals who have a significant personal bond that is or is like a family relationship, regardless of whether there's a biological or a legal relationship with the individuals. And this would direct by October 1, 2026, the director to adopt rules for exactly to kind of define how you show that. And what you need to demonstrate to show that that agreement is there. So we can return to that definition of family member later, but I'm gonna maybe keep moving forward unless the chair wants to go back at this point.
I just want, if you could just give us a broad explanation of this process of creating statute and then rules.
Sure. So the best way to think about it is here at the legislature, we set the policy. We don't necessarily define every single detail of the policy because, as you might imagine, we could literally spend years working to figure out all the details. So what we do is we delegate rulemaking authority to our basically subject matter experts at the various state agencies and departments. So for example, with wastewater, we don't come up with the rules for how you build a septic system. We delegate to the Agency of Natural Resources, who has civil engineers and soil scientists and environmental attorneys on staff who come up with the rules and then periodically update them as technology and building practices change. In this case, we'd be delegating to the division to basically say, what is it that you need to be able to determine that someone has a significant personal bond that is or is like a family relationship, regardless of whether there's official, legal, or biological status there. And so rather than figuring out all of those details here, we can certainly get more prescriptive, and we do in some instances, but in many instances we say, here's the broad strokes, and now we want you to go in and fill in all the details. Does that make sense to everyone? Okay.
Can I just add that the rulemaking process requires at least one public hearing, and the final step is review by a legislative committee on administrative rules. So it does come back to the legislature, just in case anyone was wondering.
Yeah. And that's an important thing to note. So this is a delegation of legislative authority. And there are really specific requirements around that. We have to give them clear guidance on the direction we want them to go in. There is a process that's set out in statute that requires public input. It takes 4 to 6 months to get through the process. It involves an interagency review, review by the legislature, public posting of the rule, a public hearing on the rule, solicitation of input, an explanation of why you either decided to act on that input or you didn't. And then there's other things we've added, like the agency has to analyze things like small business or environmental impact of the different provisions in the rule. And when that process is through, the last step is the Legislative Committee on Administrative Rules. And if the Committee on Administrative Rules finds that the rule is not consistent with legislative intent or the agency's statutory power, they can make that note, and it creates a presumption against that rule if that rule is then challenged in court. So if someone says that rule is invalid, the Legislative Committee on Administrative Rules, if the agency decided to go ahead after the committee said, that's not what we meant, that's not okay, they then have to fight a presumption that their rule is outside of their authority to adopt before they can even get to the rest of the defense of the rule. So there's a lot of checks set up along the way for the rulemaking process.
And when those rules are about to be considered, I receive packages asking me, with a 150-page document or less, hopefully, of the rule changes.
Mm-hmm.
And I'm given the opportunity to discuss what the committee's intent was.
Yeah. And frequently during that time, the chair and I will have a conversation, and I'll spend time reviewing the rule. The chair will spend time reviewing the rule, and then we'll talk if there are questions about whether it's consistent with the legislative intent. We'll have a conversation, and oftentimes we'll work together. If there's an issue that's inconsistent, the chair might work with legislative counsel to draft a memo to the Committee on Administrative Rules, explaining exactly why it's inconsistent, sort of setting out the arguments. It's also often the time when an agency that has issues with their rules will fix them, pending the review there with the committee. There's an opportunity for them to fix issues. And that's happened frequently in the past.
It's happened a lot recently on the difference between, because the rules change a lot on the federal money for pandemic relief. There's been a lot of these questions that have popped up. And anyway, Representative James?
And everything you just described, all the checks and balances and all the public input and all the legislative review applies to the rulemaking process broadly across the board, right? That's how it works in Vermont for all the bills that we pass that require rules.
That unless we expressly exclude it from that process, that's how it works. There are some very limited instances where we've exempted rules from that process. For example, the multi-state lotteries, they're required to adopt a national rule, usually on a very short timeline. And the state would no longer be part of Mega Millions or Powerball if they didn't adopt the rule. And so for those, we've allowed them to just adopt that rule because all they're doing is literally cutting and pasting the rule, and then that becomes the state's rule on that. But in 98% of the rulemaking cases, there is this drawn out process with multiple stages of public input and legislative review. And then the opportunity at the end, if a member of the public still feels like the rule is not appropriate under the statute, to actually challenge it in court.
You mentioned the lottery, but it's also almost any compact where every piece of legislation has to be the same in every state. So there's no room for us to change it substantively because it's part of the larger, it's part of the compact.
The option for the state is yes or no. So, and if you decide no, then you opt out at that point.
That's different than here, unless we're in a compact with other New England states to provide this.
Yeah, which in this case we aren't.
Before we take a break, and just to jump in before, as you finish up kind of with section 3, remind us this timeline then. So if this passes and becomes law on July or whatever the dates are at the end of the bill, but basically starting on July 1, 2023, the process to create this begins. So there's, according to this bill, when would collection begin and when would pay 15 months later? So what is the linear breakdown?
Sure. So takes effect July 1, 2023. You then have initial setup work that happens for 2 years after that. During that time, on or before April 1, 2025, the bulk of the rules have to be adopted, so that the reason for that is that if you're going to start collecting payroll taxes on July 1, 2025, employers need to know what the process is, how they're going to be collected, how the appeals process is going to work, et cetera. And so this requires the administration of the program to basically be mostly set up and planned out prior to the first taxes being collected, which would start on July 1, 2025. And then starting on October 1, 2026, individuals would be eligible to collect benefits. This is based on the model of getting a reserve and a healthy fund set up, just to ensure that you don't have the program immediately putting itself in the red. We'll get to a little later. There's an advance payment from the state that I know you talked about with Joyce and Patrick yesterday briefly. It's got a placeholder dollar amount in it. And depending on how we finalize the program and figure out the numbers, that dollar amount can change. Or depending on whether you even want to keep that in here. But for most employers, they wouldn't be paying contributions until July 1 of 2025.
And I mean, on or before, obviously there's a deadline. In the unlikely event that they're done by January 1, 2025, does everything else move up as well, or can it?
It could. It would take legislative action.
Okay.
So, yeah.
I want to take 10 minutes right now.